Thank you so much for joining us today. Hope everyone's well and safe. I'm Lee Leopard. I'm the Senior Creative Manager here at the Liens Law Firm. We just wanted to go over a few things before we start the presentation. I've kind of muted the majority of you so far, so we'll just ask that you stay muted during the presentation just so there's no background noise coming in. And then we will have a quick Q&A at the end of the presentation. This will be open up for any kind of questions that you may have for Jessica. And just, I ask that you submit questions via chat, be as short and concise as you can in your questions for her, and I'll read them out for everyone to hear, and then she'll answer as well. And please feel free to follow along and fill out the handout that we sent to you yesterday. Today, I would like to introduce Jessica Mora. She is our lien specialist at the Liens Law Firm. And Jessica, why don't you go ahead and take it away?
Hello, everybody. Hopefully you all are doing good and staying safe. So I have been doing liens for over 9 years, and they're very tricky. And I'm kind of just going to give you a rundown of what you need to know to make sure you guys are doing them correctly, or at least getting some type of idea of what all you need to make sure you're filing your liens. So pretty much we're going to go into, can everybody hear me? Lee, can you hear me?
I can, yes.
Okay. Sorry, it got booted me out. So pretty much we're going to do commercial projects. And we can go into the intro.
Okay.
So what is considered a commercial job? Spec houses. Spec houses, as you know, is if it's a builder building a house, that is considered a spec house. Hotels, multifamily, shopping centers. Commercial. When it says commercial, hospitals, schools, police stations, fire stations, those are not considered commercial. Those are considered public works, which is a different timeline, different criteria. So, and I do want to say that just because some people do think those are commercial and they're really not. Another important thing is, who are you? What is your position in this construction project? Are you the general contractor? Are you a supplier? Are you a subcontractor? That bases off, that's important because you have to know what your statute timeline is, your statutory, sorry. So these questions are for you to ask yourself in the front end. If you're a general contractor, what does that mean? That means you're in direct contract with the owner. Being the GC on the job is you are the original contract, whether it's a small job or a big job. If you are in direct contract with the owner, you are considered the general contractor. That is always a plus for you. We can go to the next slide. So the reason why it's a plus for you is because you have what's called a constitutional lien or a breach of contract directly with the owner of the property itself. Okay, a constitutional lien. To have that, you have, like I said, you have to have the contract directly with the owner. To figure out if they're really the owner, there's what's called the CAD. I'm not sure if you guys are familiar with the CAD, and every county has a CAD, whether it's Bear County, Travis County, Harris County, Forbin County. They all have a website that you can go on to, put in the address of the project you're working on, and it's going to give you some type of information. It'll give you the owner's name and their mailing address. That information is very good for you to have because you can always use that in your contract to make sure you guys are, your contract is directly with that owner for that property. Next slide. So for a constitutional lien, step one, make sure you have all the correct information. The owner's address, the total amount owed, the legal description where the work was performed. On that CAD, if you look at the information, it has a legal description. That information you are going to need if you have to file a lien on that project. Two, because you have a constitutional lien, you do not have to provide any notices. You can file your lien at any time. as long as the owners continue to own the project. Meaning, if you have a contract with, for example, let's say Bob the Builder LLC, and Bob the Builder owns that property, and that is who your contract is with, and they did not pay you, as long as he continues to own that property, you can file your lien at any time. You do not have a statutory timeline to do that, as long as that property does not sell. Okay? Once Bob the Builder sells it, you're out. You no longer have lien rights. So 3, file the lien. The owner's name must be on the lien, the legal description, your total amount due, what type of work did you perform, and when you performed that work. The constitutional language must be on that lien. The lien must be signed, notarized, filed of record. You don't have to send the other notices, but you do have to send notice of the actual lien being filed within 5 days of filing that lien. I have seen where some people file their lien and then wait for that lien to come back. You do not have to do that. You can send them a copy of what you're filing just to make sure you're getting it out on time. Do not wait for that lien to come back because it will take more than 5 days. Okay. After you filed your lien on a commercial job, you have 2 years to file a lawsuit to foreclose on your lien. If you do not file a lawsuit within 2 years, you have not perfected your lien on a commercial job, which means they can send you a little love letter after 2 years that says your lien is now invalid because it's past the timeline. Remove it. You have to remove your lien or they can sue you for that. You cannot refile a lien again. So make sure you know that. You can't, after 2 years, say, can I refile my lien? No, that's not how this works. You get one chance and one chance only. Next slide, please. Subcontractors. This falls under subcontractors and suppliers as well. You have what's called a statutory lien. Statutory lien means you have to follow the statutory guidelines since you are in not the direct contract with the owner of that property, which means the owner has hired a general contractor. That general contractor has hired a subcontractor. That subcontractor goes and purchases material from a supplier. That owner does not know who is at that bottom of the chain. So unless we follow the statutory guidelines, they do not know, okay? Which means we have to send them notices. You are required to send them notice. Again, how do you find out who that owner is? Just like on the constitutional lien, you can go look at the CAD to find out who those owners are. The general contractor, if you don't have their address, because you do have to send them notice, the Secretary of State website will give you that information. Either the Secretary of State or the Texas Comptroller as well provides information as to their mailing address. Your notices. So this is kind of tricky. The first notice to the general contractor is by the 15th day of the second month the debt was incurred. The debt incurred means when you performed your work, not when you invoice, guys. Like, it's when you did the work. If I did the work January 29th, my deadline starts in January. Even if I invoice in February, it goes back to when I did the work. Second notice is to the general contractor and the owner by the 15th day of the third month when the debt was incurred. Not when the work was performed, not when invoiced again. These notices must be sent out via certified mail return receipts. So they do have to go the old-fashioned way to the post office. Make sure you get the little seal with the date on it. All notices must be sent out by the 15th day of the month. Holidays and weekends are no exception. All notices must be sent. They can be sent early, they just cannot be sent late. Next slide, please. So the timelines. These are the timelines that are very, very important. Like I was saying, if you did work in January, I did work in January, I have not been paid by March. On March 15th, my first notice to the general contractor must be sent out. Certified mail. If you see the sample on, well, to my right, your left, I guess, it's the green cards, the certified mail. That receipt, you take that to the post office and they will stamp it. It has to have that stamp on there to prove that it was sent out on time. First notice, second notice is deadline for the owner and the general contractor by certified mail. The lien must be filed by May 15th. Here is a little trick that a lot of people have claimed that don't really understand is you do not have to file your lien until you're done, but you still have to continue to send notices out. So if I did work in January and February, my first notice to that general contractor can have January and February, and I sent it out in March, which then gives me till June 15th to actually file my lien. In the meantime, I'm still sending out that first notice that I've already covered. I can send out my second notice in April for those months. If I continue to work, I just continue to send out notices with an updated total amount. But my lien doesn't have to be filed till I'm completely done. Next slide. So filing the lien, owner's name is very important, legal description, the total amount owed, what type of work did you perform, and when the work was performed. So the date of the intent notice, which is the second notice, has to be on your lien. The statutory language, the lien must be signed, notarized, filed of record in the county where the job is. Notice of the lien must be mailed out within 5 days to all the parties. Via certified mail return receipt. Filing lien may help you recover unpaid debt incurred when an owner, contractor, or subcontractor does not pay for service, material, or labor. So pretty much if a subcontractor does not pay their bill, notice is going to the general contractor will usually stop the funds. If you pick up the phone and call them and say, I'm owed money, I was hired by this sub or by this contractor, you're getting somebody's attention. Once you start sending out these notices, they're going to know that you're serious and you're going to follow the next step. So it's important to do that. But they also know these timelines like the back of their hand. So if you do send them out late, they know that they're late. If you do not follow this process, the next thing is to file suit against the person that hired you. And a lot of the times, they don't have the funds to pay you. So this is protecting you by saying, okay, I have an interest in that property itself. Next slide, please. So that is pretty much a simple breakdown of it. I know you guys might have some questions, so feel free to ask. Lee, do we see any questions so far?
Let's see.
Can I ask
Okay.
a question?
Oh, sure thing. Absolutely.
So you mentioned that if a job started in 1 month and continued into the next month, does that mean all of the deadlines also get pushed a month, or is it only from the day that the work got started?
So it starts when you're owed money. So if you start in January, but they don't owe you until February's invoice, then it starts there.
So it starts, okay, I get it. So it starts when the due date is, not when the work.
It starts when they owe you money. So let's say you did January work, but you have to invoice for January work, right? But you did February work and they didn't pay you for February work. That's when your timeline starts. Would start in February, so you have March, April. You have 45 days to send them that first notice. So if you're owed for work done in February, your first notice has to go out by April 15th.
Okay.
Perfect. And Trisha asked a question as well. She said, Jessica, how does retainage apply to this?
So that is another crazy thing. Retainage is, so technically you're owed retainage because they're withholding 10% out of every draw. So we've seen it where we are actually sending notices out for that retainage amount. But they're telling us that retainage is not due till 30 days after final completion. Well, sometimes retainage isn't paid until a year out. So to answer your question, once you are done, send out your notices and file your lien for your retainage. That is the only way you're going to guarantee to get paid for it.
Okay. And please feel free if you want to unmute yourself and ask a question, or send us in the chat any questions you may have. We definitely want to use this time to get clarification for any of your cases, and what your any questions you have. Yes, Edith just sent in a question. Let's see, I joined the meeting late. Did you mention where to get the format?
So there isn't really a format you can use. I know what we've done for our clients in the past is we'll give them the first notice that they can send out. The second notice is kind of tricky because you have to make sure you have all the right addresses. I don't have a format that I can provide, but like I said, you can always look at the lien notices, statutory wise, and that you can get an idea from there. If I can add one more little thing, if you guys are mostly subcontractors, in your general contractor agreement with them, or that contract you sign with the general contractor, it has the pay when paid clauses. Please understand that you still have lien rights, that you have not given those up. Just because it has that in there does not mean you do not have the right to file lien. Even if you sign that contract and it says that you're not going to file a lien, they cannot stop you from doing that. So sorry, just wanted to put that out there. Go ahead, Lee.
Okay, waiting on a couple questions. All right, another question. What is going on with sending out a notice of intent during COVID-19 if the post office is closed?
So the post offices are not closed. They're actually open because they are considered an essential business. So just because COVID-19 is going on right now does not mean that the lien process stops. Notices are still going out. We are still working those letters, filing those liens. The county clerk's offices are still open. The timelines do not stop, guys.
Okay, thank you, James, for just sending in a question. Since the general contractor is working from home because of COVID-19, how would all of this apply?
So it's pretty much the same thing. It doesn't stop anybody. If you're out there working and you're not getting paid, you still have to make sure you protect those funds. So if you're owed money for last month's work, you will be sending out your notice the 15th day of May. It's not stopping, even though they're working from home and they haven't sent you a check. Trust me, they're going to be holding their money right now. Everybody's trying to hold on to their money. I am seeing more and more clients calling about not getting payments. It is important that you guys follow your timelines and send out these notices.
I have a question regarding my earlier question about the retainage.
Yes, ma'am.
Does the clock start after you're completely done, or is it on a per retainage, like per invoice, and the retainage on those invoices?
So that's where it's been kind of tricky, because I would usually tell our clients to send out notices with every invoice, but now they've changed it a little bit where it's at the end of the job. So as long as you send out your notice, once you are done and you pretty much file your lien right after, then you should be covered for retainage.
Because all I have left is retainage remaining on my
How long
contract.
ago did you finish?
Probably we invoiced back in January. However, we finished physical work probably last week because there was just some things we were waiting on them for. They're like, go ahead and invoice. We got invoiced on final payment, but again, we didn't finish physical work till last week.
So is the project actually completely done itself?
Our portion, yes.
Your portion, the entire project isn't done.
Yeah.
I would start sending out your notices and filing your lien for your retainage.
Yeah. Okay. Yeah. It's just because it's not even in our contract to hold retainage. That's a whole nother thing. They're like, well, we're legally allowed to hold retainage according to the Texas law, even if it's not in your contract. And I'm like,
That is true. They have to
okay.
withhold retainage because if not,
Yeah.
they're responsible for it.
And that's the GC, right?
So what it is, it's supposed to be the owner holds retainage from the GC, but now the GCs are doing it to make sure if you didn't pay your suppliers, they have money withheld from your agreement to be able to cover that cost. That's why they do that now.
Yeah. I thought that you didn't have to withhold because you're being withheld on the owner. So why am I taking the responsibility if it's not in our contract?
That is so true, but they're just, they've
Yeah.
made it to where they are trying to protect themselves, which is hurting you, honestly,
Okay.
and
Well,
pushing your money out.
it's helpful with the timeline. Thank you.
So if you guys, I think Lee will be sending all of that out to you guys so you guys can have that. But that is your lien Bible, guys. Trust me, those dates are so important. And like I said, the 15th doesn't matter if it's on a weekend, on a holiday, they go out the day before. Post offices are open on Saturdays. They're not open on Sundays. I mean, it's like clockwork. You do not miss the 15th day of the month, ever. Any other questions, Lee?
Yes, a few more just came in. Kind of a frequently asked question that we get. If we know that they won't receive the letter at the business address right now, should they still send to the home address if you know it?
So your job is to send it to their registered address, whether it's their home, their office, it doesn't matter. If they're not going to receive it, that's not our fault. Our only due diligence is to mail out the notice. Whether they pick it up or not, that is on them.
Okay. And Mariano, thank you so much for sending your question. If you're owed money from work done in December and it's past the deadline, how will that affect work done in February and March that has not been paid yet?
So what I typically do, and I'll be honest, is I'll send out my notice for February and March with the total amount. But your actual lien that you filed, you cannot include what's owed in December because you didn't notice for that. And that would be invalid. So you just file your lien for the amount that is valid.
Okay, thank you so much. Another question came in. They have a project that is currently in the process. The GC is a government project. They hired a contractor. Let's say Carlos that hired a contractor, Ken that hired us. We have not been paid. They're asking for my worker's social security and tax number. Can I still do something?
Yes, you can. If you have not been paid, first off, you must send your your GC notice, which is the first notice. If it's a government job, like you said, that is public works. That is a different timeline. It is much shorter. You're sending out the first notice at the time, like on the timeline given. The second notice to the owner, that is actually a bond notice. That is an affidavit that you're sending to an insurance company. It is completely different. You would have to get a payment and performance bond, whether that's from the GC themselves or the actual city that the work is being performed in. But you can do something.
Thank you so much. Just got another question in from Trisha. What about funds trapping notice? We would be able to send this even if they don't send lien notices.
So that is the second notice. the second notice that you're sending out, the second month notice has to have the fund trapping language in there. So it does say that you're trapping those funds, which
Okay,
makes
great.
the owner responsible if they continue to pay the general contractor after.
Perfect. Thank you. And please feel free if you want to unmute yourself to ask a question or send any more questions in the chat. And I will be sending everyone a follow-up email. It'll have Jessica's contact information, all of our contact information if you want to call, email her, and any questions that you may have that you didn't think of in this moment, and as well as the presentation. So you have the booklet, but we'll send the presentation as well for you to use. And again, Jessica said it perfectly. That will be kind of your guide, your map that you'll use during this process. It's pretty straightforward on when you look at it on the guide, but it's definitely a lot of confusing things. We want to make sure you all know and understand.
Where you have to be patient. It takes a lot of time to get them. And trust me, it's not fun to go to the post office and wait in line to get them stamped, but it works out in the end, and it's to benefit you guys and to protect your money. Okay.
I missed the first few minutes of the presentation, so I apologize if this is going to be redundant, but insofar as contracts, the general, not the general contract, but maybe like a master services agreement or a contract that you have with a company that's reoccurring, do we have to set up the contracts to accommodate the liens, or do the liens in this lien process work in parallel or standalone? Basically, do we have to make the contract accommodating to the lien, or are the whole lien process an add-on?
It's an add-on. You don't have to accommodate your contract to the lien statute. You have the right to file a lien no matter what, whether it's in the contract or not.
So quick follow-up, is there a way to craft our contracts to make them more accommodating to liens?
I would have to see your contract.
I was just wondering if there was something that we could do, just because we tend to get stiffed pretty regularly, and we're not sure if it's in the problems in our contract, or if it's just we simply aren't filing liens on companies when we should be doing them.
You're probably not filing a lien on a company. Are you a subcontractor?
We are.
Okay. So
sometimes we're a subcontractor, in fact.
That's the thing, is if you're a sub, you're not notifying the general contractor that you're on the job and that you're owed money. Therefore, they don't even know that you're there sometimes. So even if you changed your contract to have somebody else sign, it just gives you a breach of contract against them. It doesn't give you any lien rights on it unless you send out your notices.
But we do have lien rights to the subcontractor if they're the ones that have employed us.
You have a lien, when you have lien rights, your lien goes against the property itself. So remember that the lien is going on a physical property, which that owner has no idea who the sub or the suppliers are. They only hire the general contractor. So even if your subcontractor, your sub sign, or person signs your contract and you're saying, I'm gonna enforce my lien rights, you still have to notify that owner and that general contractor that you're filing a lien. You can't file a lien on somebody's property if they don't even know that you exist.
Got it. Thank you.
We did get another question here. It is from Mariano again. Does every job site require a different lien notice, assuming that it is not the same owner, but the same sub that hired you?
Yes. Every job is their own letter, their own notice. If you have multiple jobs with the same general contractor, you can send each notice in one envelope. If you have multiple jobs with the same owner, you can do the same thing. But each job has to have their own notice.
If we have any more questions, again, just feel free to send them via chat. We just got one. Does there have to be signed contracts to file a lien?
No. Verbal contracts are allowed in the state of Texas.
Okay.
However, it is harder to prove. So please at least send some type of invoice, show something, because when you send out that notice, that first and second notice, you have to have a statement or an invoice attached to prove that you're owed that money. So it can be a written invoice on just those little notepads that you get from Office Depot. If it's one of those, I'm fine with that. You just have to have something that you've submitted.
Okay, a few more just came through. One from Nicole. Are the practices of liens different in the state of Louisiana?
Yes, they are. They are very different. Actually, I would have to pull the book for that, but they are different.
Okay, thank you. And Raul just sent a question as well. Does the first notice only go to the GC or both the owner and the GC?
The GC. The first notice is only to the general contractor. Mind you, if you want to send it to the owner and the general contractor and get it out the way, you can. You can do your notices early, you just can't do them late.
Okay, thank you. Definitely want to keep this open for a little bit longer for more questions. Please feel free to send more, any questions you may have.
I have a tactical question. If you do repeat business with some of these people, I understand everything's on a case-by-case basis and on a customer-by-customer basis, but when you're dealing with maybe a large company, are they just used to having liens filed against them and they don't take it personally? I imagine there's probably a spread of reaction, like there's a distribution, like some are okay with it, some are like furious. What is this considered normal practice?
It is considered normal practice. Again, you're not going to send this notice to the person that gives you the most business and you don't have a problem with them paying you a month or two later, right? It's going to be on a case-by-case basis. You don't want to lose that relationship. Most companies are used to seeing these notices. Now, if they get upset because you send them a notice, there's a reason why they're upset. One that I've seen most likely is that they've already been paid and you've just put them out there to say, hey, I've been paid, but I haven't paid my guy. So they know these timelines, they know they're going to get something. And it's just saying, hey, I'm not trying to, stir up the pot. I'm not trying to get you into any trouble. I just want to protect my lien rights and just being upfront and honest with them.
So is it considered a good practice to let them know that you're about to do this so you don't embarrass them in front of their customers?
Yes, it is. Another thing that I've noticed is phone calls. If you actually pick up the phone and call them, that works. If you know who the general contractor is and you're saying, hey, I'm reaching out, I've let my subcontractor know that I haven't been paid and they're not paying me, I want you to know that I'm going to send this notice out. that usually gets somebody talking. And if they've paid somebody, they're going to call them and be like, why am I getting this if I've already paid you? Picking up the phone helps a lot.
We did just get another question in from Raul. Can you just repeat the retainage timeline requirement for lien notice or actual lien?
So retainage is, you can, one, send out your notices as you're doing the work and as they're withholding it, or two, as soon as you're done, send out the notice and file your lien. Because retainage works differently. Retainage is usually paid out to the general contractor. Oh, not usually, supposed to be 30 days after final completion. And when I say final completion, I mean everything on that job site is done. Everybody is completely done. They have a certificate of occupancy and they're turning over the keys to the owners. That is final completion. When you're done, you should send out your notice and your lien, because that can be a year or two down the road. You're not entitled to retainage until they've been paid retainage per your agreement with them. But your lien has got to be filed. One more thing that I wanted to add also is, even if you're coming at the very end of the job and you are done and the project is complete, once that project is fully completed, you only have 30 days to file that lien, because that's how long the owner is supposed to withhold that retainage. So if you come in doing the landscaping, which is, I'm guessing, one of the last things on the job, you only have 30 days from when they turn over those keys. So do not go past the 30-day mark. So I know that it takes sometimes a very long time because some of you come in on the front end. Keep an eye out for the jobs. That's all I can say, is just keep an eye out. Any other questions, Lee?
Thank you, Ronaldo. Just a comment saying great presentation and thank you. Thanks, Ronaldo.
Thank you.
We did just get another one from Richard. Thank you so much. Can a landscaper paid directly by the owner put a lien on unpaid work?
Yes. Yes, you can. You have what's called a constitutional. If you have that direct agreement with the owner and you were not paid, that is a constitutional lien. You can file a lien whenever you're ready to, before they sell that property.
Thank you. Okay, any other last questions? Definitely want to make sure that we're answering everything for you.
Hello, do you hear me?
Yes, I can hear you.
Yes. I have a question. So I think I heard that you were saying that if we did work in, let's say, January, and then we didn't send a lien, because technically for January we have to send a lien notice, and I believe it's March 15th.
March 15th.
So let's say I did not send a notice for the January, but I'm still on the project, and let's say the February. So can I send that lien notice for February and January at the same time, or is that possible?
Who hired you?
I'm sorry?
Who hired you?
I am a subcontractor, so I work for generally for the GC.
Okay, so if you had an agreement, if your contract is with the GC, did you send the GC invoices or a pay application?
Pay applications, yes.
So when did you send them that pay application?
Usually we send them on the 20th, and it's towards the end of the month. So we work. Let's say we work January, and we send a pay application on the 20th of that month. towards the end of the month, and then so
So pretty much you can send out the intent notice, which is the second notice, because if you did work in January, your general contractor received your pay application, which means they knew that they owed you money. So that is a little loophole we can try to use to say, yes, I didn't send out my first notice, but you knew that you owed me money. So right now, what's important is to make sure you get that second notice out to the owner and the general contractor.
okay. And
So
then
yes,
so
send out the notice for April 15 with the full amount owed.
okay. And so the first notice only goes to the GC.
Yes.
The second notice goes to the GC and the owner. And then I guess the third month, if I haven't been paid, is gonna be an actual lien, correct?
Correct.
Okay, thank you.
Thank you.
Perfect. And I had another question here. Let's see. I've seen before that even with a lien property, they were able to sell the property. Why is that?
So one, they've either put the money in escrow. Two, they have bonded around your lien, which means if they put the money in escrow, you have to actually sue them to try to get your money out. Two, bonding around it means they have put the money up with an insurance company that has provided a bond. The bond is filed of record, and they can actually sell the property now. So then at that point, you would have to sue the insurance company to get the funds for that lien.
Perfect. Thank you so much. And just a reminder, we will be sharing this PowerPoint, the presentation to all of you. We'll send an email as a follow-up. So any other questions that you may have, please feel free to reach out. Jessica is the lien specialist at our office, so she'll be able to answer any and all questions for you. And we just had a note come back in, and if you haven't seen the email from us by end of day, please do check your spam. It sometimes may go to that portion of your inbox. And then I know we will be sending, again, that follow-up after this afternoon for you all.
All right,
Okay,
thank you.
Thank you so much. Appreciate you.
Thank you.
Thank you.
All right, thank you all so much.
Have a great day, everybody.
Have
Bye-bye.
a great day. We appreciate it. Thanks so much, Jessica.
No problem. Have a good day. Bye-bye.